day of October by a taxi cab. She further claims that on the day in question, the defendant operated this car or cab in a reckless and negligent manner at an excessive rate of speed and on the wrong side of the road, and failed to give proper warnings of the approach of the cab, knocking her down and causing her to sustain injuries for which she now seeks money damages. Her husband also sues, claiming he was deprived of the comfort and society of his wife and was caused to expend money for the necessary and reasonable expenses he was put to in the care and attention which he had to give to his wife because of the injuries that she received. I might say to you, gentlemen, now that in the event that the wife does not prevail, of course the husband's case naturally falls. The defendant disclaims any liability and denies that he was the owner of the taxicab at the time of the accident. You are to determine as to a question of fact who was the owner of the taxicab on the 31st day of October 2008. The law says that the license number of an automobile coupled with evidence that the defendant held the license constitutes what is known as prima facie proof that the defendant was the owner, but the defendant, however, may by evidence overcome such a presumption. Section 59 of the Vehicle and Traffic Law provides if a motor vehicle or a motorcycle be sold under a contract of conditional sale, whereby the title to such motor vehicle or motorcycle remains in the vendor, such vendor or his assignee shall not be deemed an owner within the provisions of this section, but the vendee shall be deemed such owner notwithstanding the terms of such contract until the vendor shall retake the possession of such motor vehicle. If you determine to your satisfaction by the evidence in the case that the defendant was the owner, then you must return a verdict for the defendant. If, on the other hand, you find that he was the owner, then the court charges you that in that respect he is to be held liable for the injuries received at the hands of the chauffeur. This is what is known in law as a case of negligence. In every action of negligence, there are two questions to be considered and two facts that the plaintiff must prove in order to make out his cause of action. These two facts are, first, that the defendant was guilty of negligence which caused the accident, and second, that the plaintiff was free from negligence contributing thereto. The law does not allow a person to recover damages from a defendant for injuries if the negligence of the person injured has contributed to bring about the injury, because one cannot recover for injuries which he himself has been instrumental in bringing about. So it does not make any difference how negligent the defendant's driver may have been if the plaintiff was guilty of contributory negligence. Negligence, gentlemen, is the absence of due care, and due care is the care of a reasonably prudent person under all the circumstances in which he or she finds himself. It may also be defined as the omission to use that degree of care which the circumstances require. In other words, it is the failure to observe for the protection of the interests of another person that degree of care and caution and vigilance which the circumstances justly demand, and whereby such other person suffers injury. Now, in determining whether the plaintiff was negligent, you must determine whether the plaintiff, under the circumstances in which she was placed, as she saw the facts, as they were shown to her under the circumstances, exercised the care of a reasonably prudent person. Determine what took place. Determine the facts. Then determine for yourselves whether the action of the plaintiff under those circumstances was the action of a reasonably prudent person. Now, the burden of proof is on the plaintiff in respect to all these facts, which you have to consider. She must satisfy you of each fact as asserted to make out her cause of action. And by the burden of proof, I mean the preponderance of the evidence. Preponderance of the evidence does not mean the number of witnesses. It does not mean the quantity of the evidence. It means the quality of the evidence. You must, in determining each fact in this case, consider this, that she has the burden of proof as to every essential fact necessary to make out her cause of action. She must establish it to your satisfaction. If she does not do that, if she fails to do that, if the evidence either preponderates for the defendant or is evenly balanced, then the plaintiff has failed to make out her cause of action, and your verdict must be for the defendant. Now you come to the question of the credibility of the witness. And there you are the judges to say what credence you will give to each one of these witnesses. Judge people here as jurors, just as you judge them in your ordinary walks of life. Make up your minds whether they are telling the truth or not. Bearing all these things in mind and the probabilities of the case, determine how the accident happened and what the facts are. Now, members of the jury, you must scrutinize with care the testimony of an interested witness. Your test of an interested witness is, does he or she stand to gain or to lose by your verdict? Of course, an interested witness can tell the truth and often does tell the truth, the same as one who is disinterested.
How fast was that?
Let's see. $6:40, 5 into